Welcome to the fourth week of this class, and in the fourth week we're going to be talking about vocational expert testimony, and we're going to be talking about legal and ethical issues as well as marketing issues and private practice issues and dealing with legal issues surrounding laws such as the Americans with Disabilities Act. The first thing I'd like to talk with you about is vocational expert testimony. We are frequently called upon by plaintiffs and defendants, and let me just, for those of you at this point who are still confused about who's a plaintiff and who's a defendant, a plaintiff is someone who's been injured, and the defendant is typically the insurance company or the employer, and through the insurance company. And we are frequently called upon by either plaintiffs or defendants to provide vocational expert testimony. And this can be on the basis of doing an independent vocational evaluation, or it can be on the basis of any case management and rehabilitation work that we've done with the individual. And we may be called upon as in our capacity as a professional, and we are called upon to provide vocational expert testimony. Now, the venues in which we might do this can be an administrative hearing, such as a worker compensation hearing, which would be considered to be an administrative law process, or it can actually be in a civil case, so like a long-term disability matter or a personal injury, an automobile accident would be in a civil environment. In a civil environment, that means going down to the courthouse and testifying in front of the judge and the jury and the plaintiffs and the defendants. If it's an administrative hearing, that may mean just going to the worker compensation hearing, where there's a judge, where you've got the plaintiffs and defendants, but there aren't other people who are there. Or in some cases, particularly in administrative hearings, we may testify by in the attorney's office or our office, and that testimony would then be played back at a later date, or the transcript would be used during the hearing. In terms of the issues relating to expert testimony, a lot of rehabilitation professionals are kind of ambivalent about going and testifying. Others are outright nervous and scared about it and don't want to have anything to do with it. Other people, on the other hand, find this to be a challenge and enjoy testifying in various types of forensic matters. The basic premise, or the basic premise that we do this, is to provide information to the trier of facts, the judge, or to the jury, depending upon the case, about the individual. And so, even though we might be hired by one side or the other, our job is not to advocate for one side or the other. Our job is to present fair and objective information which conveys the nature of of what we have done and what we have found. Now, having said that, you'll also find that those who do advocate for one side or the other, the plaintiff's attorney or the insurance company, the employer's attorney, the insurance company's attorney, will want to have the facts that we presented in the best light for their particular case. And when we provide testimony, there will be what's called direct testimony, and then there'll be a cross-examination. And usually in direct testimony, the person who asked the questions will be the person who hired us. In the cross-examination, that's going to be the other side. And many times in cross-examination, the person doing the cross-examination will either try to refute what we have said, or they'll try to discredit us, or they'll try to in some way impugn our credibility and impugn our objectivity. The nature of testifying follows three broad areas. The first area is, and I believe that there will be several videotapes in which you'll see how this plays out. The first area is to provide the qualifications of the individual. Anytime somebody testifies in court, they have to be found to be qualified as an expert witness, and that's based upon a person's education and their experience, the employment they've had, articles they've written, things they've done professionally. So the first phase of the direct testimony is based upon establishing the person's credentials and acceptance by the court as an expert witness. The second phase is to present the methodology the expert witness utilized. That methodology can be such things as the interviews that the person had, the information collected from those interviews, the reliance on background reports from physicians and psychiatrists, psychologists, and others, and also any testing that was done, such as academic testing or aptitude or interest testing. So the second phase is for the expert witness to talk about the methodology that was utilized. Then the third phase is for the expert witness to present the findings and conclusions. And usually the findings and conclusions would be based upon what the expert witness found in terms of the interview and the testing and the past work and so forth. Now, for the most part, in doing expert testimony, the important factors in terms of the methodology would be a reliance and giving more weight to what physicians and healthcare providers say objectively about the person's ability to function. A lot of people that we will meet will say they can't work because they have too much pain. That's just simplifying things, but a lot of people will take that attitude, that approach. And if we were solely to rely on that, then the vast majority of people that we work with would be found to be disabled. On the other hand, what is more credible is considering what the physicians and healthcare professionals, psychologists, psychiatrists say about the person's level of functioning and levels of ability. And we would then match in terms of giving opinions if, for example, you have a doctor, and I'm simplifying this, says this person can lift 20 pounds and needs to sit and stand alternately. If those are the restrictions, we might be asked a question, well, this person was a manual laborer and had to stand all day and lift 100 pounds throughout the day. So one question would be, can this person return to the past work? We'd have to say no. This person is unable to return to the past work. Then the next question might be, can this person do other work? And we might say, yes, this person can do other work, and they would need to do work that would entail lifting at no more than the 20 pounds and sit and stand alternately, which would mean they need a job performed at a bench, desk, table, or workstation. Then we might also factor into that equation our academic testing, which may indicate, let's say, if the person's illiterate, we would then have to say, but our testing indicates that this person is unable to read, write, or do arithmetic. So that would preclude this person from being able to perform various types of clerical and cashier and counter clerk and counter sales types of jobs, and would be relegated to simple factory labor types of work. We would then be asked to describe jobs the person can do. In some cases, we might be asked to come up with some sort of calculation as to the loss of access to employment that this person now has as a result of this injury. We might be asked to indicate how much money this person can earn, and we might be asked, or we might be asked, did you find out how much this person was earning before, and then how much can this person earn now, and look at differences between what they could earn before and what they could earn at the present time. So these are the types of questions on direct testimony we might be asked. There might be situations in which we'll have conflicting medical opinions, and again, it's not our job to say which healthcare person is correct. You might have one person who indicates the individual can only do that lifting of 20 pounds, but another physician may say that there are no restrictions on this person's activities, in which case we would have to say, well, if that were the case, this person can go back to what they were doing before. And then it's up to the advocate, the attorney for the individual, to argue as to why the physician who says this person can only lift 20 pounds is more credible than this other physician who says this person can go back to what they were doing before. And in doing that argument, which is not something we would argue, but in doing that argument, it might be that the treating physician is the one who said this person has these restrictions versus a non-examining or non-treating physician doing just an independent medical evaluation saying that this person has unlimited abilities. So those are the types of issues that we will get into. And sometimes we'll be asked questions about which physicians would we rely upon, treating physicians or evaluating physicians. And sometimes we'll be asked, well, if the evaluating physician has board certification in the area of expertise, such as orthopedics, is that not more credible than a treating physician who may just be an internist? So some of these questions that we get into may border on gray areas for us in terms of credibility and qualifications. But again, these are the types of questions that we might be asked. But basically what we're asked on direct examination is to provide opinions about the employability of the individual. And again, if we're asked by the plaintiff is going to be more interested in what this person can no longer do, whereas the defense is going to be interested in all the things the person still can do. So it just depends on which side. Now, our opinions should be the same no matter who has hired us, but the nature of the questions that we're asked are going to be asked in such a way as to bring out the information that's more favorable to the side that hires us, that's on direct examination. And you'll see these things come out in the videotapes that you'll be looking at. On the other hand, in cross-examination, the cross-examination is designed to, and again, it depends on how the direct examination information was presented, but you might find a cross-examination gets into areas that might be what you might consider somewhat personal. For example, to impugn your credibility, they might ask you, how much are you being paid for this evaluation, to show that you're getting a lot of money and your opinion obviously is being bought. Or they may ask you, how many cases have you done for that attorney or that insurance company in the past year? Again, to show that you do a lot of work for them, and so obviously your opinion is going to be what they want it to be. Or they may ask you, how many times did you meet with this person? Again, to show that you really don't know this individual if it's only been once over a long period of time. Obviously, if you've been the one doing the case management with this person, then that question probably is not going to be asked. They may ask you questions such as, which are not as personal, but they may ask you questions about the physician perhaps who says that there's nothing wrong with this person. They can go back to do the work. They may say, well, if you believe that physician, then obviously there'd be no loss of ability to do jobs, and this person can go back to whatever he or she was doing. They may look at your report and if there's anything that comes in that looks like it's where the person may be magnifying the symptoms or the pain, they may they focus on that and say, did you consider the fact that this person, you know, did not, as you state in your report, appear to give good effort or was not totally cooperative, those sorts of things. So cross-examination may be designed, again, depending upon how the direct examination goes, may be designed to impugn your credibility and to show that you are not an objective witness but actually are a biased witness, and or it may try to highlight the favorable points that the other side wants to bring out. So cross-examination is designed to be used in such a way as to highlight the other side's issues. Many professionals feel uncomfortable about doing depositions and testifying because they feel that they cannot just state what they feel and what they did and how they did it and what their conclusions are without the questions from either side being framed and presented in such a way as to just present those aspects of the answer that are going to be most favorable to them. So that's one of the reasons why many times people are reluctant to engage in doing depositions, because of just those factors. And as I said, our job is not to advocate for one side or another, but just to present information to one side or the other, or both sides. The job of advocacy is for the individuals who represent one side or the other. But testifying is something that you may be called upon to do, and if you're called upon to do it, it's something that in some respects, if you've never done it before, for the first time you do it, then you know it's not as if you're a professional witness. If you do it a lot, then someone might view you as being more of a professional witness. But obviously, as the more you do it, the more comfortable you become with it, and the better at it that you will be. When I say better at it, I mean better at being able to answer the questions and be able to present the information that you have. Because the bottom line in doing testifying is not to show everybody all the things you know, but to be able to answer the questions and get out the information that you've got to present, and then move on to the next area, because whether it's a judge or a jury or a combination, they just want to get to know what your opinion is and how you got there and what it's based on, without a lot of other sorts of issues. And again, in your professional practice, if you do work in private rehab, you might rarely be called upon to do this sort of testifying, or you might be called upon to do it quite frequently. Now, in the videos that you're going to see, if you do have questions, I want you to raise those and to ask those questions, and we will answer them and try to clarify them, and hopefully that'll make it a more interesting and enjoyable experience and learning experience in terms of the nature of expert testimony.